judgment said that it was a testament to Texas's sovereign independence from the world court's foreign judges. So the best word from Texas is that compliance is something that we'll have to work towards. And as we sit here today, Texas officials are preparing Mr. Medellin for execution by lethal injection on 5 August. And 4 other Mexican nationals, all in Texas, are in imminent threat of receiving execution dates, all of them without having received the remedial and mandated obligation of review and reconsideration. So on August, in a little bit over a month, the United States will be in a situation of irreparable breach. In light of the development of these facts, Mexico made the, again, difficult decision to return to the ICJ, and 2 weeks ago we argued on a request for interpretation that the ICJ clarified that the obligation of review and reconsideration is an obligation of result and not an obligation of means. Concurrent with that application before the ICJ is a request for provisional measures of protection, which, like the 3 previous requests, asked that the ICJ order the United States to take all steps necessary to prevent any executions until the Avena judgment is complied with. We await the ICJ's decision, and we expect the next few weeks to be very busy on that front. So in the remaining time, let me just turn to where I think international law stands post-Medellin. When it comes to ICJ judgments, we continue under the view first articulated in Breard, reiterated in Sanchez-Llamas and in Medellin, that these judgments, these ICJ judgments, are entitled to, quote, respectful consideration, end quote, in courts. But I submit that that's a very narrow respect in light of Medellin, because there, even a judgment that was directed at the judiciary relating to federal treaty rights like Avena is not susceptible to enforcement by the highest federal court absent some additional act by legislature. So what respectful consideration means for a court interpreting domestic law when it comes to ICJ judgments remains a question. And in the 4 months since Medellin was issued, we've seen it cited 6 times in lower courts. 5 times was specifically in the context of the Vienna Convention on either suppression motions or 1983 acts to simply reiterate that the Supreme Court has not decided the question of whether the Vienna Convention actually confers judicially enforceable rights. 1 was in a copyright infringement case in the Southern District in the Electra case, in which it was cited in a footnote and rather strange proposition that because the World Intellectual Property Organization treaties were not self-executing, the court could not consider statements by Congress during the ratification of those treaties in interpreting the U.S. Copyright Act. That's a bit of an odd logic, and I don't believe that that's going to get much traction, but you never know. So those are the only 6 cases so far, but time will tell as to whether and how exactly the Medellin case will impact domestic law and international law domestically. I have heard through various media reports and some academic articles the notion that this upends the entire scheme of international dispute settlement mechanisms. I don't think that that's the case. If you look to the UN Convention on the Law of the Sea, if you look to UNCITRAL, NAFTA arbitration provisions, New York Convention, Washington Convention, there's very specific implementing legislation in that context. Having said that, what we do have are about 70 some odd treaties that, like the optional protocol, confer compulsory jurisdiction on the ICJ. And I think that in those narrow fields where those treaties operate, that is the area where you'll see the most impact with respect to Medellin. I believe that perhaps, and this is just a guess and it will have to be borne out, that perhaps in the more straightforward commercial cases involving money judgments or property or inheritance rights that are the subject of some of these treaties, there will be courts that won't follow the very specific reasoning of Medellin to come to different conclusions, because Medellin could, and I hope that this is the case, be construed very narrowly, like Dames and Moores, to apply to a very specific situation that arose in the death penalty criminal context. To be sure, however, I think one of the greatest costs is just the uncertainty that's created, which in and of itself undermines the perception that the United States is an adherent to the rule of law, that the United States as a treaty partner can actually pay out on its promises. And I think that and the responses we've been hearing from various ambassadors is one of the most is an enormous practical implication of the Medellin decision. And I think the other practical implication is that it puts a huge burden on Congress to not only understand this extraordinarily complex area of law, but to be mindful and somehow be able to appreciate all of the execution and enforcement situations that might arise in the context of a given treaty in order to insert magic language having to do with self-execution, which I think is a hugely difficult exercise indeed. And with that, I'll turn it over. Thank you very much.
Thank you very much, and thank you to the ASIL and the DC Bar for inviting me. I realize, as they say in soccer, that we are into injury time, and I will try and keep my remarks very brief on some of the issues raised and the implications of the Medellin decision from the perspective of a treaty practitioner who's had the fortune to be on both sides of treaty creation and dispute resolution. One thing I think it's worth noting is that Medellin is the follow-on case to a pair of cases, Sanchez-Llamas and Bustillo, which the Supreme Court decided in 2006. In one of those cases, there was a similar issue of procedural default. In the other, in Sanchez-Llamas, there wasn't. And in Sanchez-Llamas, the court had to consider an interesting set of issues outside of the question of state issues of procedural default. Sanchez-Llamas asserted a similar claim of a violation of Article 36. I don't think there's any dispute that Article 36 had not been complied with in his case. The question was, did this individual have an individual right under the treaty, or was the treaty merely a compact between nations where any rights of an individual were derivative and it was argued below could not be asserted by an individual? The court in Sanchez-Llamas did not have to resolve that. The court assumed, without deciding, that an individual person has a right under the Vienna Convention on consular rights, and moved on to decide the case on the basis of remedy, which is another significant issue here. The remedy that Sanchez-Llamas sought was suppression, something similar to the scheme under which Miranda enforces rights under the Constitution. And the Supreme Court decided and rested its decision on the view that even if Sanchez-Llamas had a right, and even if that right had been violated, suppression of his confession was not the appropriate remedy. And they did this after a very robust assertion of the right of the Supreme Court to announce what the law is, with a rather modest assessment of what the power of the Supreme Court was to enforce an unquestioned obligation of the United States under international law. The Supreme Court said that they did not have the right to supervise state courts, and that the remedy of suppression was not one that was appropriate in that case, and therefore unavailable. So one question here is, even assuming one gets around the procedural default issue, which is at issue in Avena and is the major source of contention in Medellin, what is the remedy that is available to induce compliance by state law enforcement officials in particular with an unquestioned federal law obligation that applies to them? This issue, I think, is one that the court will probably see again. The decision was that suppression was not a remedy, that you weren't going to see some sort of analog to Miranda, even though the State Department had seemed to use that analogy in trying to instruct state law enforcement officials in ways in which they could inform defendants of their rights. But the Supreme Court did suggest that there was a right that could be invoked in U.S. court by a defendant, and while it's not clear exactly what remedy there would be, at least in the context of voluntariness of a confession, there is some suggestion by the Supreme Court that there is a concrete individually enforceable right under Article 36 of the Vienna Convention. So that's one point I think is important.